That should come up a lot clearer on this.
Yep, that's good.
Cool. Okay, so we're on to part 2. It's a bit of a continuation. So, again, these are the elements of what you're supposed to learn. So, we're going to talk about the different types of law, the more black and white aspects of law. So, you get an understanding of where you come from, where all this legal control over your profession comes from. And so, if you understand that, you go to court, at least you'll have an idea of the system that you're going into. So, criminal law. So, what's criminal law? It's an action brought by the police or a public prosecutor. Public prosecutor? Yeah, right. Against whoever has allegedly committed a crime. And it's about crime. It's about breaking an act or regulation. So it's a black and white. You break into this person's house, you committed burglary. So that's a law that you've broken. It's illegal. So there's a standard of proof is beyond reasonable doubt. So, and reasonable doubt is a huge question in the law. It always has been. What's reasonable doubt? That's where judges make decisions about reasonable doubt. And that's where we talked about the other types of law. The judicial law made by judges gets common law. They're the things that they make that decision about that affects the law. And the purpose of all criminal law is to punish an offender. Whether you agree with what the punishment is or not, that's a personal issue, but that's the purpose of the law. We go into civil law. Right? We're talking about civil law, law of torts. Okay, so what is it? It's an action brought by a citizen against another citizen. So, Mr. Smith versus Mr. Brown. In a case of they've defamed, defamation, that's the word I was looking for. They've defamed a person's character. Okay? Patient against the nurse for negligence. They didn't give me my medication, or they didn't make my bed properly. So the standard of proof is on the balance of probabilities. Is it likely to have happened? Yeah, it probably did. And they'll base their compensation on that balance of probabilities. So, 50, 60%, they're asking for $1 million. Will they get, $100,000 or $500,000? Depends on if they really think it happened or not. They have to believe, it's a bit like, so I suppose, what percentage, they have to believe 51% that it happens to prove it. But if they think it's 90% or 100% certain that it actually happened, then they'll compensate appropriately. That's, again, a decision for a judge to make. And as I mentioned, it's the purpose of the action is the compensation for wrongs done. And it's judge-made law that decides that. So it follows the doctrine of precedent. So if you're determining the balance of probabilities, they will look at other cases. What's happened in the past is precedent for what's happening now, and if it's a different decision, that will set precedent for the next time it happens. Civil law. It doesn't involve the police in the action that's being taken. An individual initiates the action. So it's not a police. If it was a policeman on his own private basis, he could take a civil action. But as a nurse, and we'll stick to our nursing profession, it would have to be a nurse taking the action. It can't be you go to the police and make a complaint. You decide to go to your lawyer and say, I've been wronged. And the plaintiff considers they have been wronged. That's the person taking the action, is the plaintiff. Need to prove owed a duty of care. That's what we're going to talk about specifically about nursing. So that person owed a duty of care to me. I really should have had my bed made with hospital corners. because it made me uncomfortable that they weren't there. So the duty of care, they had, if there was, that was part of their job, and that was their duty of care to that patient to give hospital calls because it made them comfortable, then that's a reasonable action. If it's not considered fair and reasonable, then they won't give compensation for it. So it's a lower standard of proof. And the end of it is there's no punishment as such, but there's a financial compensation awarded. So coroner's court, whole different world. Requires the reporting of a particular death. So it establishes a procedure for investigation of deaths. And we'll talk about that shortly, about the type of deaths that they need to investigate. Helps prevent death from similar circumstances. So the coroner can make recommendations about how to stop a death happening this way again. If it's neglect, or someone that didn't do something, they did an act or omission that contributed to someone's death. And they report to Parliament that addresses the need for legislation to improve the service, prevent these things happening. And just as an aside, I suppose, any person can request a coroner's inquest into a death. And they'll determine, the coroner will determine if it's necessary, because they are expensive processes, coroner's investigations. They will look into it and decide, yeah, well, we need to look at this because he's right, these circumstances aren't normal. And as a nurse, you can request it. As a patient or a family member of a patient can request it. So the coroner's court, these are the reasons they do a coronial inquest. So reportable deaths. So for instance, someone's stabbed, they're murdered, whatever, they die, that's a reportable death. Person is unknown. The old John Doe, Jane Doe thing. If you don't know who the person is, then they'll have to investigate it. They investigate not only to find out who the person is, what the cause of death was. Suspicious circumstances. You come in, you find a plastic bag over your patient's head, probably considered a suspicious circumstance. So they would have to investigate that. Doesn't matter what it is. If they're in your care or in any care, in a hospital, and there's a bit of a, I suppose, a caveat to that. Depends on why they're in hospital, when they've been treated, what they've been treated for. Someone who's in palliative care, and they know that the outcome's inevitable, they're going to die, they won't necessarily have a coroner's inquest done because they died in a hospital, because it was reasonably expected that they would die. And they'll get someone to sign a death certificate. We'll talk about that shortly. If they're in custody, you've heard about Indigenous deaths in custody. Same as if you're in a police cell, doesn't matter who you are, and you die in the police cell, or the police have arrested you and you die in the back of the police car. You're in custody, they will investigate it. That covers not only the person, but it covers the police as well. And if a death's not reasonably expected to occur as a result of a health procedure. So you're in theatre, you're having your big toe removed and you die. And you're a healthy person. They're going to investigate it because it wasn't reasonably expected that you'd die from a local anaesthetic. And they will investigate. Cause of death certificate, not issued. So there are two types of certificates they issue as a rule. One's a certificate of death, of life extinct. So they get the doctor at the time to make sure that you're dead. They feel your pulse, they check your eyes, they look for neurological reflexes, they do an assessment on you. Yeah, they're dead. They're not going to come back to life again. Then there's a death certificate that says that this is why you died, and they have to have a doctor, and there are guidelines around that. And I'm not exactly sure of the exact guidelines, but I believe they have to have seen you within a certain period of time, and that they have to have expected you to die from the illness that you died of. So in the case of someone in palliative care, your GP's been treating you, you go into hospital, 24 hours later you die. After you've seen the GP, he'll sign a death certificate because he felt that that was the outcome, was inevitable, and on the information that he gets from the hospital, that's what you died of or in related to. The coroner's findings. What can a coroner do once he looks at a cause of death or a death? Who the deceased is, so we mentioned, they're unknown. They can determine who they are, how and when and where they died. The cause of death, so is it a stabbing, is it from a illness? And it must not include statement as you, it doesn't talk about guilt and innocence, it doesn't call it murder, or it determines that you died. That's up to the criminal system to determine guilt and innocence. He's not there to determine that. He's determined as to why you died. But they can make recommendations, as I mentioned before. They'll recommend to the hospital that they have more staff on a ward, or that if your obs are 4 hourly or 1 hour in an hourly obs, then you need someone to sit with them, a special. They're the type of things that they can recommend, or this is the type of procedure you should be using. And they'll get expert opinion to determine that. And they can put you into a tribunal. This nurse needs to be prosecuted because they did the wrong thing. So they'll put you up in the SQNC there, but it should be NMAC or APRA, so that they can review your practice competence and see if you meet competency standards. And if not, they can deregister you or recommend training, so they can refer you back to your professional body. They do that for doctors as well. Coronial inquest. So mandatory for the coroner to hold an inquest if any of the aforementioned things occur. So the question, what powers does a coroner have? Well, he can investigate, he can determine a cause of death, he can determine what the circumstances surrounding the death and whether that death was accidental or not. Lots of things he can determine. But good question, do nurses ever give evidence? Yes. A simple, straightforward answer. It is quite common for nurses to give evidence. I've been lucky, I've been to the coroner's court 3 times. And it's all about deaths. Because I'm an emergency nurse, we often have deaths that are suspicious or deaths that are unexplained. And it's not going to be done the day after. One of the first instances, the first time I went to a coroner's court was 4 years after the event. And I was expected to be able to recall the events. That's where documentation rules. If you don't document it, you won't remember it. If an ED nurse, I went into there and they said, do you clearly remember this? And I said, no, that was 300 resuscitations ago. And the coroner looked at me. I said, I've worked in ED for the last 4 years. He went, fair enough. And he said to me, and I was given a name. I wasn't actually given any details until I got into the court. And he went, this is what happened. And I remembered the events. And then they gave me a copy of my notes to look at. Do you concur with these notes? And my comment was, well, I wrote them, of course I do. And being an ex-policeman, my notes, I've got to say, were spot on. They were timed, dated, signed by everybody, and he was really quite impressed with it, the coroner. He said, I've never seen this come from a nurse before, where you've got everybody to sign the notes. And everybody agreed with my notes in their statement. They said, and that was just because I'd had that additional training. But it was so important because it was 4 years down the track. And I didn't know all the circumstances as to why they were investigating it. And it was all about whether or not the doctor went in the ambulance with the patient. And they didn't, even though they were continuing to fit, because at the hospital I was at the time, we had 2 nurses, 1 doctor on night shift. And therefore, we had 4 sick patients in the emergency department. We couldn't leave those patients because we put those lives at risk for another person who had a potential risk. And she died of something that we didn't pick up. But it was reasonable. In those days we didn't scan people, we didn't have x-rays on site, we didn't have ultrasound on site. The CT we could have investigated for a small hospital. And we had to send them for those investigations. So that's one of those things, and that's why I'll investigate. And this was actually the reason it was done, the inquest was actually done, was at a family request. They were looking for a civil suit, I feel. Never happened though. So, law of torts. It's about civil law. Subtle hint in your assessment. It's a question they ask about tort. One party suffers damage or loss at the hands of another. Tort refers to a wrong, and it is derived from the Latin and Old French. Okay, a negligent or intentional civil wrong. Tort law is about civil wrongs. It is about righting wrongs suffered by the plaintiff. That's the person making the complaint. Compensation is the usual outcome, not punishment. But they can recommend in some cases that it be prosecuted, but they can't actually punish. So, some of the common ones, civil wrongs that involve nurses, negligence, they didn't do something, an act or omission. So, it's not just what we do, it's what we don't do sometimes. Consent. We didn't get consent to do a procedure. And remember, there are different types of consent. Trespass, assault. And we'll talk about those a bit further, what trespass, assault and battery are. Because they might not be what you think. It's not because we went onto their land to see them. Restraint or false imprisonment. Confidentiality. Yeah, I got Mr. Smith in here. Yeah, he's got herpes. Over the phone to their friend who happens to know them. Confidentiality is broken. They will sue you. Defamation. Common one. Bailment. Everyone's going to say, what's bailment? Look it up. Documentation. Witnessing wills. It does happen. Nurses are sometimes asked to witness someone who wants to change their will. That'll end up in court, particularly if someone's put out by the change of the will. You won't sign them because you're not able to, but you still can ask to witness a change. The coroner's court. What happens in a coroner's court? Contracts. And standards of care. They're all things that can involve a civil action. Okay, negligence, some of the things that we talked about. Under law of torts, where a patient could be injured, right? Act or omission of an act which leads to an injury. So, for instance, we're walking our patient out to the toilet, and they're supposed to be on their walker, and we decide, no, I can't be bothered getting a walker. We'll just walk you out by yourself. You'll be right. It's only a short walk to the toilet, and they fall. They break their hip. Who's wrong? It's got to be that nurse because they should have used a walker. Even though they were rushed, that injuries occurred because that person did an omission. They did not get them their walker. And it will come up because you have to explain it, and there are always witnesses in hospitals. Negligence. There was a duty of care standards of care are involved, there's compensation and proofs necessary. So what is to be proven? There was a duty of care, that we breached that duty of care, that damage resulted, and damage was reasonably foreseeable. So, because we walked our patient, if they fall, they're elderly, there's a potential they'll break their hip. And they did. Therefore, it was foreseeable. There's lots of other things, but that's a very simple one. So, trespass, assault and battery. So, trespass isn't about always going on their property. Right? It's threatening and or touching a person's body or entering their property without consent. So, when they say entering their property, they could be going into their suitcase. You go in there, open up their suitcase to look for their jammies, you haven't got their consent. If the extreme end of the scale, they could complain about that. Or threatening them, shut up or I'll give you a smack in the mouth. Sometimes you want to say that. Professionally and ethically, no you can't. You may feel like that, keep it to yourself. Because that can be threatening. Standing over someone and saying, I'm going to give you this needle now. No. Okay? Assault. Right? Can be the fact that they feel threatened by me. I've got a big needle here. We're going to give you this needle. Just behave. I've got something that they're scared of. Huh? Unwanted physical contact. And that could be grabbing their arm to give them something. They didn't want it, you grab it, assault. So it doesn't actually require actual touching. Battery. Okay? Intentional physical contact of another without their consent. You don't have to injure someone. I walk through the door, just get out of my way. That's the family member, I'm going to the patient. Pushed him out of the way, he staggered a bit. I've actually committed battery. Even though he's got no harm done to him, he's just moved aside, I've still touched him, and I could see assault and battery. So, assault and battery. So we have the right to decide what's done to us. And if we go against their decision, without their consent, it can be assault and battery. Unlawful restraint. So, unlawful restraint, intentional restraint of a person. So, when I first started many years ago, we won't say how long, you could tie people into a chair with a sheet to stop them falling out. You could put seat belts on them. You can't do that now, not without their consent or the consent of a person acting for them, because that's unlawful restraint. Putting bedsides up in a hospital can be unlawful restraint. And that sometimes isn't even noticed, but when the person climbs over the bed and falls that extra distance, does more damage, we unlawfully restrain them, can lead to an action. Restriction of movement is total, right, with no obvious means of exit. So we lock them in a room. They can't get out. That's restraint. And we give them something. And again, when I started out in ED, someone caused a problem, were manic and running through the emergency department, causing chaos. We could tackle them, get them to the ground, give them medication to slow them down. No, not anymore. We have to get an order, we have to make sure that people are, or we have to determine if someone's at risk, who's at risk, before we can do that. So, we can get restraints, chemical and otherwise, ordered through medical staff. But you've got to remember that the moment they order them, they're legally liable. So, they're often reluctant to do it. Must be monitored regularly for a change in conditions. So as soon as they're back to normal, we can't keep them in a restraint. Next of kin should be notified, absolutely. We should, where possible, get permission if they don't have their own power of attorney. whoever's acting for them, get their permission. Right? Have the decision reviewed all the time. Keep on to the doctors about whether they still need that restraint or not. And document, document, document. Defamation. Okay, making statements. And it can be a colleague that can do that to you. Okay? Need only have been between two people. You got to, that's that balance of probabilities. You've got to believe that it was said. It's a tough one between two people, and if someone else hears, absolutely. Even if it's the truth, you're an idiot. Right? They may have done something silly, and they may be an idiot for doing it, but you calling them an idiot can be defamatory, particularly if someone else hears it. And they go, oh, that guy's an idiot. Don't know why, but he's an idiot. That could be, in a shallowest sense, could be considered to be defamatory. So the law on nurses. Remember, nurses are not usually charged with criminal offences unless you do a criminal act. Nurses are charged with civil offences such as negligence. That's the more common. Nurses are asked to account for the standard of care they provide. They'll expect you to understand your duty of care, what standards are appropriate. Vicarious liability. It's about the organisation being held accountable for the actions of its staff. So, trust me, companies, if you've done the right thing, will stand by you. If you haven't, you're all on your own. So, when you're giving care, you make sure you know what you're doing. And if you stay within your duty of care and in your law, you're quite safe in your practice. I've never been sued yet, and I've been going for 20 odd years or more. So, consent, one of the big issues for nurses under legal and ethical standards. How do we make sure we've got consent? Written consent is the best way. If it's in writing, it's signed, it's great. But there is verbal consent, but you really need to prove verbal consent. You really would like to have a witness to verbal consent. And implied consent. As long as it's not a major thing, implied consent's okay. But I'd still like to have a witness to implied consent. So, look mate, I'm going to pop a cannula in your arm. Do you mind? And they put their arm out to you. That's implied. Or I'm going to take your blood, and they roll their arm over and pull their shirt up. They don't have to say yes, that's, yeah, look, go ahead, give me permission. But I still normally say, do you mind if I do this? I still would prefer actual consent, but it comes down to the crunchy, you've got implied consent. So, if consent is not gained, the nurse can be charged by the police for assault and battery. Straightforward. You grab someone's arm to do a blood pressure, you haven't got their consent, then it can be assault and battery. So, the main elements, it's got to be given voluntarily. It covers the procedure that you're doing at the time. You can't come into your patient and say, look, I am going to do your blood pressure, do your pulse, later on I'm going to do your dressing, and then I'm going to do this and that. You need consent for each procedure. So there's no point in going, you can tell them what you're going to do over the day, but that's, every time you come in to do the procedure you need their consent, because they can change their mind. And they're entitled to. They can withdraw consent at any time. So it must be informed. So you have to explain the risk of the procedure. And I think before we mentioned about the truth, veracity. You need to be honest. This will hurt. Explain the procedure. You're going into theatre, this is what they're going to do. They're going to give you an anaesthetic, or they're not going to give you an anaesthetic. And they have to have legal capacity, and we talk about adults and adult guardianship, and you just have to have a good read up on legal capacity. What's an adult, what's not an adult, we'll talk about it in a minute. So, all procedures require consent. Medical procedures, the doctors are responsible. They're going into surgery, you haven't got a consent form signed, the doctor needs to come out and get that consent form signed. Because they need to explain what they're going to do in that procedure. Same as they can't explain a nursing procedure to them for you. You need to go out and explain what you're doing and get their consent. So health professionals can witness a signature. This does not validate the consent, only witnesses the signing by the patient. So if you come in, do you mind watching this patient sign this consent form? Doesn't mean the doctor's told him anything. If you want to be a witness to the consent, you have to be there while he explains the procedure. And it would be a totally separate form for a valid consent. So, okay, the doctor will have responsibility for obtaining informed consent. Right, the patient can alter consent form prior to signing, so he can change whatever he wants on that. He can, and often the doctors will name the procedure, and if he changes it to right leg, then you've got to go, okay, the doctor's got the wrong leg, or the patient's a bit confused. You need the doctor back to explain it. Patient can withdraw consent any time. Implications for nurses, absolutely. If we do something and they've withdrawn their consent, we're assault and battery again. Consent forms provide documentary evidence, but does not establish a valid consent. So you need to have all those elements of a valid consent and be prepared for it. Children. Parents and legal guardians can consent. Make sure you've got their parent. I had a case where a nurse got consent for a procedure on I think it was an 8-year-old. And they took them into the room and they were going to sew them up, and the person was sitting there. And I looked at them and went, "How old are you?" She said, "Oh, I'm 14. I went, "You're not this child's mother, are you?" She goes, "No, I'm not." And I said to the nurse, "Who gave permission? Where's Mum and Dad?" "Oh, Mum and Dad aren't here. But the sister gave me consent." Sister wasn't able to give consent for the child. Now, Mum and Dad came and gave consent, and that was all fine. But we would have been subject to being sued if we hadn't picked that up very early. Okay, the girl looked 18, but she was only 14. She just didn't behave like an 18-year-old. So you just got to be aware of that. And make sure you know who you're talking to. Are you Mum and Dad? If not, are you the legal guardian? And get them to sign that they are the legal guardian. Okay? Emergency and life-saving treatment without consent if the parent and guardian is not locatable. And that's the doctor's decision to make. Alright? We can start CPR if there's no one around. But if they want to give medications and do things that we're doing doctor's scope of practice, that's the doctor's decision to make. Okay? Different states, different levels of consent. Right? 16 to 18 can consent for themselves. 16-year-olds in a lot of states, if they're living by themselves, they're not with their parents, and they're responsible for their own well-being, that sort of thing. And children under 14-year-old cannot consent without a parent being present. So valid consent for people with intellectual disability, but you need maybe someone with an enduring power of attorney or adult guardianship. Look up the Adult Guardian. It's a great website, tells you a lot about guardianship and what the adult guardian can do and can't do. Documentation, documentation, documentation. I'll keep repeating that one. It's what gets you out of all your trouble. So ANMC dictates that nurses must communicate effectively, and that's verbal, written, right? So we need to have good documentation. Quality documentation helps us and makes us accountable for our practice. It can ensure client is included in the decision-making process. So if you're talking to the client, tell them, spoke to the client about the procedure, he's waiting for the doctor for consent. It says that you understand that he knows what's happening to him. And that's how you got that information. Instead of client consented, and then 4 years later they come back and say, how did he consent? Oh no, I wrote that down. I must have got consent. You don't look very good in a court of law. And remember, it's on balance of probabilities if it's civil. So, supports continuity of care, informs on treatment instructions, supplies historical information on and for the client, provides a legal record, a platform for reflective reasoning. Why did we do this? It's reasoning for not only you but the client as well. And provide data can stop a complaint. Oh yeah, look, we talked to you about that. I noted it here in your notes. Oh yeah, you did too, sorry. It was a busy day, they were a bit scared. They'll remember it. Provide data for financial resources and allocation of staff. That's fair enough. Standards. You've got it in your Kingstone, factual. It's really good. It's very good for writing your documentation. Mandatory reporting. When a patient is at risk of hurting themselves, when a patient is at risk of hurting others, when a patient is at risk of being hurt by others, we have to report them and protect. We are advocates for our patients. Privacy and confidentiality practices. What can the nurse do to protect the client's privacy and confidentiality? We teach it in labs, don't we? When we're doing a procedure, pull the curtains around, close the door, right? Just remember, curtains aren't a barrier for your voice, so you can't yell at the deaf person, you got a bit of trouble with your bowel there, Mrs. Jones. She doesn't want the lady next door knowing what her bowel habits are. So it's about communicating in other ways. Write it down if they can understand it. Or take them somewhere where it's quieter if you can and explain it to them. So just be aware of that. Confidential curtains aren't a barrier to your sound. Curtains, you can't see you doing things if you're exposing someone's. It doesn't matter if it's a male or a female. If you're exposing their chest, their right to privacy is just the same. And sometimes we forget that, particularly with males. I've seen nurses just go in and take off their shirt and start doing an ECG on them. And I've gone up to them and said, would you do that to a female? No, I'd close the curtains. My frowny face, and the curtains close. Okay? A couple of little questions and good things to remember. Negligence is a breach of which type of law? Civil law. Law of torts. Civil. Negligence in performance of duty of care can come from what actions? There are a number of them we mentioned. Poor standard of care. Injury sustained by a patient under our care. When we omit to do something for someone under our care. So really, really important. We think about what we do to make sure that we aren't negligent in our actions. If we miss something, we admit to it, we write it down, we put it out there, because that will keep us out of trouble. You forget to give a medication, be honest about it. Don't compound a mistake with a lie. Don't sign for that drug. I've seen nurses do it, and I've had to take appropriate action against the nurse who did it. Sign the drug off. Oh, I forgot to give it. Oh, I'll just sign it off. That won't hurt them. But they still didn't get that medication. And it wasn't a life-saving medication, but they're entitled to that. And that was wrong to sign for it. I would have forgiven them. I would have said, oh, well, look, we'll go and see if they need the medication. It was just a pain medication. And we'll go and see them and see if they need it, and then we'll give it to them. And just record in here the time that we gave it and accept that we made a mistake. But no, it was a cover-up and it was wrong.